Good evening, everybody. We're going to go ahead and get started. I think some more people might trickle in as we go on, but we have so much to cover. We want to get rolling right away. I'm Victoria Nielsen. I'm the chair of the Immigration and Nationality Law Committee of the City Bar Association, and we are putting this panel on along with the Social Welfare Committee. I wanted to give a special round of applause to Susan Welber, the chair of the Social Welfare Committee, who really did a lot of the heavy lifting in pulling this panel together quite quickly, and to Neil Kalan from the International Rights Committee, who is taping this for us. So if you're not here, which you all are, you can watch this afterwards on the City Bar website. This is such an important topic that we're covering today. DACA and TPS covers literally hundreds of thousands of people who have been living in the United States, many of them for more than half of their lives. As we were all contemplating what the future holds for people with these statuses and what we can do as advocates to try to preserve these statuses, I think this really could not be a more timely panel with a great group of experts that we have here. And with that, I'm going to turn it over to Claire Thomas, professor at New York Law School, to lead the panel. Thank you.
Thank you so much, Vicki, and thank you, all of you, for being here for this very important panel. I don't want to take too much time for introductions, but I want you to all know that our panelists are incredibly accomplished. You have brief summarized bios in your handout on the back page. Thank you again to Susan Welber and to the committees that helped to co-sponsor this event and to Make the Road New York, our co-sponsoring organization. So quick introductions. At the far end, at your far right, we have Professor Alina, who is a professor of clinical law at New York University School of Law. Next to her, we have Sienna Fontaine, who is the deputy legal director at Make the Road New York. To my immediate right, which would be your left, we have Diane Lucas, who is an assistant attorney general in the Civil Rights Bureau of the New York State Attorney General's office. We have we have Amy Taylor at the far end. Amy Taylor is, and so that would be at your far right. Amy Taylor is the legal director of Make the Road New York, where she leads a team of 40 attorneys and advocates to provide legal services to low-wage workers and immigrant New Yorkers. And last but definitely not least, I have Hassan Shafiqla, who is the attorney in charge of the Legal Aid Society's Immigration Law Unit. And without further ado, I'm going to turn it over to Professor Alina to walk us through a little bit of the historical background and lay a lens for DACA and TPS here in New York. Just so that you know, in terms of questions, we have note cards, which hopefully have been distributed to you. We will be, Kate, thank you, who's going to stand up right now, has generously offered to collect the note cards and bring them up to me for time to time so that we can answer all of your questions. So when you have a question, please fill out a note card, and we'll hopefully be able to get to all of our questions tonight. So without further ado, I'm going to turn it over to you, Alina.
Thank you. Just as a technical matter.
And then,
Thank you.
that you?
Yes.
Yeah. And then, oh. Cool.
Thank you so much.
Thank you, Alina.
Well, thank you, Claire.
Of course.
And thanks to Susan and Vicki and everyone who organized this panel. It's incredibly important. I know for those of you who chose to come here on a random Monday evening, there's something that brought you here, and I think we all have people in mind when we start thinking about this topic. You know, I certainly think about my clients like someone I'll call Cynthia, who through her TPS is not only supporting herself, but a family of 4. I think of people who are not only clients, but friends, family members, and students at NYU, where I teach, who have DACA, who have TPS, who have been able to turn those opportunities into so much more. And we stand to lose quite a lot if those opportunities are taken away. And in particular, in the immigrant rights movement, so much of our work is driven by people who have DACA and TPS and have been able to move us forward and protect so many more people from the deportation and detention regimes that we've been seeing and living under for a long time. So it's incredibly important that we're able to come together and figure out ways to protect them. For my portion of the conversation, I've been asked just to give a historical perspective, a little bit of background on what DACA and TPS are, and leave the really great, interesting stuff for my fellow panelists to actually talk about what's been done and what people should be thinking about. But I just wanted to start by talking about deferred action for childhood arrivals. As most of you know, deferred action, or DACA as it's been referred to in shorthand, is something that was announced back in 2012 by President Barack Obama. It was a direct result of active immigrant organizing by youth who were directly affected in the wake of the failure of the DREAM Act to pass Congress. At the time, they really pushed President Obama to come up with a different kind of solution. And what DACA provides is not the path to status that the DREAM Act would provide, but it provides a temporary reprieve from deportation and work authorization during that period. And of course, this isn't considered legal status. It's not a path to citizenship, but it has opened the doors for many people to get certain opportunities that they hadn't previously been able to get. And we're talking about numbers close to 800,000 people who have received DACA through this program, who've been able to work, and not only work, to be able to get driver's licenses, to access certain benefits that are tied to folks who are considered to be here under color of law. And it's really transformed not only their lives, but the lives of their family members. And I think that's an important thing to consider, that it's not just the 800,000, it's all of the people that they support by having this reprieve from deportation and this work authorization. Now, temporary protected status is something that I think is emerging in conversations about immigrant rights. People tend to not know as much about it as they do DACA because of its history and how long it's been around in many cases. But essentially, temporary protected status it's a status that was written into law in 1990 as part of the Immigration Act. It protects people who are facing a civil conflict or a natural disaster in their home country. It's country-specific as opposed to the individual. And it allows people to get also a temporary reprieve from being deported for anywhere from a 6-month to an 18-month period. But that period can be renewed. And with that status comes work authorization. And because of the timing of when this was announced, and the ongoing nature of many of the civil conflicts and the natural disasters that have been a basis for TPS, there are people who've had TPS for many, many years. And so, if we're looking at a couple of the groups that are coming up for renewal, and this is a decision that is made by the Department of Homeland Security currently to really say, is this country still unsafe for people to go back to? Some of the people who've had TPS have had it since 1999. So we're talking about a group of people who have been living for a very long time with work authorization, with abilities to participate in American society for a long time, who haven't had to worry about their immigration status. And so this is a population in particular that I know you'll hear more about how our community needs to reach out as lawyers, as activists, to really make sure that people are coming in before an announcement might come that their particular country is going to be undesignated and that they might lose that status. And you'll also hear more about whether or not TPS can be a path to a green card. The way it's written in the law was not necessarily intended to be a path to status. It's not the way you might, for example, if you're a refugee or an asylee, it's written into law that after a period of time you can apply for your green card. And TPS people, immigrant advocates, have had to fight for that in the courts, and there's a divide, and I think that will be discussed in more detail later. And on a last note about TPS, I've listed the countries that currently have TPS. So you can imagine, you may know of people, you may have represented people who have been seeking asylum and have received asylum from these countries. I mean, TPS is incredibly important, really, because of limitations in our asylum law. For those of you who've represented people or work with people who have been seeking asylum, there are many rules that come with it about how you have to be particularly affected. So you have countries where people may not be directly targeted, by a government official for one of the recognized grounds for asylum. They may not be, obviously, when it comes to something like an earthquake or a hurricane, certainly there's not an argument that the government is directly targeting them. And so a lot of the things that come with asylum protection have been inadequate to protect people who really need the United States to step up and provide that reprieve from deportation. And so that's where TPS kind of comes into the mix. So I did want to talk a little bit about the history of these types of protections. You've probably heard a lot in the news about how DACA in particular is a very new idea, that it's something that President Obama came up with on his own, and we'll talk a little bit more about that in a minute. And that temporary protected status, there's a kind of a constant line, well, this is meant to be temporary and it's been going on too long. And again, there's a lot of painting of the last administration as being an administration that somehow has really stepped away from the history of how people have been protected in this country. But the truth is, these kinds of programs have gone back as far as President Eisenhower. Nearly every president has used the power of their office to protect people. Even before TPS became part of the statute, you have President Eisenhower and other presidents using their power under their executive authority to really give people this types of protection. And we're talking about tens of thousands of people, hundreds of thousands of people. And in fact, one of the largest examples of this was the Family Fairness Program in the late 1980s with President Reagan and President George Bush Sr. using their power to protect people because legislation was pending but wasn't available yet to protect those people. And it was a huge group of individuals, protect them from deportation in the hope that Congress would then step in. So if that sounds familiar, it should. And there's a whole host of labels that have been used, which I list on the screen, for what these types of actions have been called. They've had different names, but they're all intended to do the same thing, to recognize that the U.S. government in the executive branch has the power to protect people from deportation, particularly given humanitarian concerns. So where does that leave us now? And obviously, my fellow panelists are going to talk in much greater detail about this. But as you all know, President Trump announced that he would be rescinding DACA, that by March 5th, 2018, the program would be officially over. People who were in the works would be keeping their deferred action, but only for the period of time it was issued. And so slowly, you would have more and more people every day losing that protection from deportation. And he did it based on an argument. I'm sure many of you saw Attorney General Jeff Sessions' speech. If you haven't actually seen it, I recommend you just take a look, because his facial expression really says a lot about the way that the administration has felt about DACA and how happy it made many people in the administration to announce its closure. But his basic argument was, again, that DACA was unconstitutional. This idea that President Obama overstepped his authority, that he was doing something Congress was supposed to be doing. But the reality is that, as the vast majority of legal scholars and others in the community have said from the beginning, this is perfectly constitutional, thank you, and really an example of one of many examples, as I just mentioned, of the president acting. And it's interesting because we both kind of point to the same part of the Constitution, the Take Care Clause. And there's a long history in our immigration law that notes that in order to actually execute the law, you have to exercise prosecutorial discretion. That is part of any law enforcement agency's ability to make sure that the laws are applied fairly and that they're able to use the resources they have in the way that they feel is most appropriate to the intention behind the law. And so there is nothing particularly unusual about DACA in the course of history of how presidents have used this. It's really much more of a political bargaining chip. And a lot of the litigation that was brought forth on one of the programs that President Obama announced as a way of trying to extend DACA, which you'll hear more about, and extended also to parents of U.S. citizens and of lawful permanent residents. Again, the litigation around those issues really tried to make the point that it was unconstitutional, but it did it through a mechanism which we all like to describe as forum shopping. The people who, the states' attorneys generals from conservative states who wanted to go after DACA picked a conservative forum in front of a district court judge who had previously openly stated his disdain for President Obama's immigration policies. And so that is part of how they got the momentum, even though the majority of people in the legal community, based on our analysis, feel very strongly that this is a constitutional program. And so the next steps, I think, my fellow panelists will talk about. There's ongoing litigation, obviously a legislation push for a Clean Dream Act, and then Trump himself obviously likes to throw out tweets every now and then about how he might reconsider the program. But as we all know, he recently issued a set of immigration principles that are essentially the bargaining chips he wants for something like DACA, which involve cutting legal immigration in half and ramping up enforcement and building the wall, things that we know politically wouldn't fly, and therefore, the intentions behind all of this are going to be a big question. In terms of temporary protected status, again, there's been a long-standing movement amongst very conservative immigration restrictionists to get rid of TPS. And we know that power is given to DHS to decide the Department of Homeland Security to decide which countries really meet those qualifications. And we've already seen one announcement saying that it would be safe for people to go back to Sudan, and they're going to give a little time for an orderly period so people could get ready for leaving. And, again, these are hotly contested issues in terms of the safety. Many of the countries involved, particularly the ones involved in environmental disasters, they actively ask for their residents not to be sent back. They say they're not prepared. We've seen this in Haiti most recently. And so it's incredibly important for us as a community to stand by our community members who have TPS. And the deadlines are coming up really quickly. Honduras and Nicaragua, we're going to find out, I believe it's November 6th. That's their deadline for letting us know whether it's going to be redesignated. And we have another set of deadlines that are coming up in January. And this is going to really stun our community, particularly for the countries where these TPS status has been designated year after year for many years. People haven't been thinking about what their alternative plan is. And so we as a legal community do need to step up, and that's why I'm so grateful to be in a place where the people that are on this panel exist, because they are thinking this through and they have been reaching out to communities to help fight against these policies on the streets and in the courts. So with that, I will turn it over.
Great. Thank you so much, Alina. We always learn so much from you, and we appreciate it. And I think our next two panelists, so Amy Taylor from Make the Road New York and Diane Lucas from the State Attorney General's Office are going to talk about New York State's response and litigation efforts here. And I think our next panelist will be Amy Taylor, the Legal Director of Make the Road New York.
Hi, everyone. So Sienna and I are both here tonight from Make the Road New York. We are a membership-based organization in New York State. We currently have 4 sites where we operate on Staten Island, in Bushwick, Brooklyn, Jackson Heights, Queens, and out in Suffolk County on Long Island. We have around 21,000 members right now, and we do community organizing around issues that affect our community members' lives, and we also fight for policy changes to improve their lives. And we have a services department offering legal services, health services, and educational opportunities for our community members. We operate on a committee model, which means that every night of the week in all of our offices, you will find groups of community members coming together to talk about issues that are affecting their lives, ranging from immigration to education to LGBTQ issues to policing, et cetera. And one of our most active and engaged committees is our Youth Power Project. And our Youth Power Project engages young people around a variety of issues, but one of them is immigration. And our Youth Power Project has been incredibly active around issues of immigration reform for many, many years. Many of our members are some of the original dreamers who were fighting for the DREAM Act and pushing for the DACA program before it existed. So DACA for us is an incredibly personal issue and one that affects many, many of our members and our staff as well. We also, in our legal department, have been providing services for DACA applicants and DACA recipients since 2012 when the program was created. I believe we've filed somewhere around 4,000 applications. So we have a lot of expertise in the sort of granular issues around DACA and also documented individuals and their families. So we actually, Alina mentioned the second announcement by the Obama administration in 2014 when President Obama announced an expansion of the DACA program as well as a new program called DAPA that would have given a similar protection to essentially the parents of DACA recipients. When this program was announced, the expansion of DACA included, instead of a 2-year work permit, a 3-year work permit. And as soon as the Texas court that Alina mentioned issued their injunction holding up this program, there were hundreds of individuals across the country who had received approval for a 3-year work permit and had it revoked. So at that time, we initiated a lawsuit together with the Worker and Immigrant Rights Advocacy Clinic at Yale Law School and the National Immigration Law Center on behalf of one of our members and clients, Martin Batalla Vidal, to challenge the Texas court's injunction affecting New Yorkers like Martin, who was essentially losing his expanded DACA benefits. So I will not go into detail on that case because soon after we filed, an election happened and everyone's world shifted entirely. However, as the Trump administration took office and began to implement all of their very harsh immigration policies, our case remained pending before Judge Garifas in the Eastern District of New York. And so we realized that that was a great opportunity to address any actions by the Trump administration to touch the DACA program, since our plaintiff, Martin Batalla Vidal, is a DACA recipient himself. And Make the Road New York is actually an organizational plaintiff as well in the lawsuit. So we immediately, on September 5th, knowing that this announcement was coming, approached the court and said that we were ready to amend our complaint to add new claims and new plaintiffs to challenge the DACA rescission. I'll just put this in context because on September 5th, our offices were full of DACA recipients and family members and community members who had come into our offices to watch the session's announcement, to get support, to sign up for screenings, and there we sort of rolled out our DACA response, which this litigation is a small piece of, but we've been, sorry about that. We've been protesting, we've been doing a lot of advocacy on the national level for a Clean Dream Act and to be really clear about our priorities as an organization and a community, that any legislative response not use Dreamers as a bargaining chip in exchange for increased enforcement and border walls, et cetera. And that's very, very important to our clients and members who have DACA themselves, who often talk about their parents as being the original Dreamers, and that any trade-off for Dreamers will essentially continue to rip families apart and is unacceptable. Okay, so back to court. So we filed our amended complaint shortly after the session's announcement to challenge the DACA rescission. And our case right now has 7 plaintiffs. So Martine was joined by 6 other individual DACA recipients. They're all our members and our staff members, actually. And all of these individuals have very different stories. They all have DACA. Many of them are parents themselves and have U.S. citizen children. A couple of them own houses. They're all working. Most of them are in school, and are just an incredibly accomplished and impressive group of individuals. And Make the Road New York continues to be an organizational plaintiff. And for us as an organization, beyond our history with DACA, we also devote a lot of our resources to, or have devoted a lot of our resources to legal services and educational services related to DACA, and specifically around the rescission, have had to expend additional resources to staff up a number of clinics, to stay late in the office to serve everyone who came in desperate to meet that October 5th deadline. We've been out in the community doing Know Your Rights presentations. We've been filing renewals like mad. I believe we filed 175 renewal applications in the period between September 5th, when the announcement was made, and October 5th. So the harm to our organization is real. And of course, the threat of the end of the DACA program would mean that we would lose some of our most valuable staff members who would no longer have work authorization. So that's obviously devastating as well. So we're suing Elaine Duke, who's the acting secretary of DHS, Jeff Sessions, the attorney general, and President Trump. And our claims are primarily claims under the Administrative Procedure Act and the Constitution. So our Administrative Procedure Act claims really revolve around this federal law, which governs how agencies do policymaking, essentially arguing that the termination of DACA was arbitrary and capricious in that it reversed a longstanding agency policy without a reasoned explanation for the termination, right? So as Alina mentioned, the only explanation given by the administration for ending this program was the threat of potential litigation out of the U.S. v. Texas case, and their fact that this program is illegal, which no court has ever found. Additionally, we are claiming that because of the reliance of 800,000 individuals on this program, the claims under the Administrative Procedure Act are even stronger, because here you have a policy that's been in place for many years. Hundreds of thousands of individuals have benefited from it, but really millions of families across the country and states and employers, et cetera, have seen benefits from this program and would be harmed by its rescission. We also allege that the program ended without a notice and comment period, which is required under the Administrative Procedure Act. And another piece of this claim that's really important is that for many years, DACA recipients received notices that essentially promised that their information that they were providing to the federal government would not be used for enforcement purposes. And as you can imagine, this fear is incredibly high right now among DACA recipients who know that the federal government have their names and addresses and information not only on themselves but their family members, and are incredibly fearful of what will happen to that information. Additionally, we have constitutional claims arguing that the real motivation for the DACA rescission is racial animus, right? So this is a program that benefits about 800,000 people across the country. 93% of them are Latino, and 79% are Mexican. And we have a president who has expressed very overt racial animus towards not just Latinos, but Mexicans specifically. He's called Mexicans criminals and murderers and rapists. He has, clearly shown his true reason for ending this program. And so that obviously is an unconstitutional reason under the law. We also have a claim under the Regulatory Flexibility Act, which requires an analysis to determine how a change in policy would impact small entities such as Make the Road New York. Diane and I can both talk about the litigation. We're at a few days after our suit was filed, the New York Attorney General's office and other states filed suit as well, which she will speak to. And there are currently a number of other sister cases, I'll call them, across the country that are all being litigated right now very actively. We have a lot of ongoing discovery disputes, including one to be heard at the Second Circuit tomorrow morning. We continue to, use this strategy in the courts while we're also making noise in the street and pushing for Congress to pass a Clean Dream Act. And I'm happy to answer any questions anyone has. Thank you.
Great. Thank you so much, Amy, for educating us about Make the Road's response in the litigation that's ongoing. So now I'd like to turn to Diane Lucas from the New York State Attorney General's office to talk to us about New York State's response.
Thank you. So Amy and I have been working a lot together. So it's great to see you on this panel, as well as everybody else. Thank you for having me. So I'm from the Civil Rights Bureau of the New York State Attorney General's office. And we work to protect the civil rights of all New Yorkers and on a broad range of issues. But since the election, we've been focusing a lot on immigration. And so I do want to give another shout out to Amy and Make the Road, the National Immigration Law Center, and a number of other immigration organizations that have really helped us to get smart on immigration law, because we now have to be immigration experts, as well as experts in every other area of civil rights. And another thing that I want to acknowledge is all of the work of all of the activists and the dreamers to get us to where we are, because New York State and the other states who brought this case would not have been able to do that without the work that they have done. So I wanted to take the time out to do that. So as Amy mentioned, New York and 16 other states, plus the District of Columbia, filed a complaint challenging the termination of DACA in the Eastern District of New York. We filed it the day after the announcement that DACA was going to be terminated. We were going back and forth for a couple of weeks trying to figure out, what was going to happen and what we were going to do, and we had to act fast. And as you can imagine, it was quite challenging trying to get, at the time it was 16 states, together to figure out a litigation strategy and to do it in such an extreme time crunch, but we were able to do that. And so that I'm really thankful for. And so we filed the original complaint the day after the announcement, and then we filed an amended complaint on October 4th. And one thing I want to highlight, all of the declarations that we had to show the interest of the states and how we were harmed. So what makes us unique as government plaintiffs is that we don't need to have individual plaintiffs. We are representing the people of our states. And so how we have standing in these cases is that we have to show that our states were harmed. So we showed that our states were harmed in 3 ways. So there's proprietary interest, basically saying that we were financially harmed, our businesses are harmed, there's a significant loss in tax revenue because DACA grantees significantly contribute to all of the states in our cases. Among other proprietary interest, there's the sovereign interest. So this is to what we own as states. So this are state universities, state hospitals that are harmed. And then there's the quasi-sovereign interest, and this is the softer stuff. This is the health and the welfare and the well-being of the people in our state of New York. And that is what I want to focus on a little bit. So the declaration, so we got declarations to support all of these interests, but I want to focus on the declarations from individuals, because that's something we really wanted to highlight, given that we don't have plaintiffs. This is the way that we can have people speak. This is how we can have their voices heard in our papers. And I think it was very powerful to have statements from individuals, from dreamers who said, this is going to really, really hurt us, our families, our communities, the businesses we work for, the nonprofits we work for, et cetera. And we do think that that helped to make our case incredibly compelling. Our claims are very similar to the Batalla Vidal plaintiffs' claims. And a distinction is in our information sharing claims and basically how the federal government is going to use the information that they've received from DACA applicants. And so their claims, let me start over. So they actually address that issue under the Administrative Procedure Act, but we address that in two separate claims, an equitable estoppel claim and a due process claim. So basically we're saying that DACA applicants relied on the government not using this information for law enforcement purposes, and so the government should make good on their word, and they should not use this information for law enforcement purposes unless it's for the reasons that they previously stated. So I think the three main things that our claims represent is the way that DACA was terminated. Amy touched on this, the fact that there was no notice and comment, and that it was done in an arbitrary and capricious way. So Alina touched on this too. Jeff Sessions, Attorney General Jeff Sessions, stated that DACA was unconstitutional, and that was the reason why it was going to be terminated. Yet, Trump's comments, his tweets, he said, well, we want to give Congress more time. And then in another tweet, he says, who wants to get rid of all these DACA grantees, right? They're so great, they're contributing to our society, we don't want to do that. And also suggested that he could revisit this in 6 months if it doesn't work out with Congress. And so if the reason that DACA is being terminated is because it's unconstitutional, then all those other statements are in direct conflict with that. And so that's evidence of this not being the real reason why, and that it's arbitrary and capricious, but it also supports the fact that it's pretextual, that the reason why DACA was terminated was based at least in part by racial animus and not because of a belief of it being unconstitutional. And further support of that is there's no case that ever held that DACA itself was unconstitutional or illegal. And the other thing is the impact. So we talked about this before too, is the impact that it has on the communities, the impact that it has on small businesses, which goes towards the Regulatory Flexibility Act that Amy discussed. And that is a unique claim, at least for us in the New York State Attorney General's office. We're not normally bringing these types of claims, but looking at small businesses and small entities and seeing how the rescission of DACA impacts them. And so, yes, as Amy also brought up in terms of this discovery fight, it has been all-consuming, and it's really interesting because this case, a lot of it hinges on discovery, on what we can get from the government. And there's a lot out there in the public record, but we are really trying to seek information that the Department of Homeland Security and the Department of Justice have, and see what they think their reason for terminating DACA is, and try to get other evidence to support our claims, and we believe that evidence would support that, again, this was pretextual, and the reason why this was done was not because they believed it was unconstitutional, but there were other reasons. So with that, I will
Great.
wait to get questions.
Great. Thank you, Diane. Thank you to you, and thank you also again to Amy for taking the time away from the discovery fight to educate us about these very important issues. Our next two panelists are going to lead us through both the immigration and access to public and health benefits issues that are arising. And so with that, I'm going to invite up Hassan from the Legal Aid Society to lead us through all of immigration law in about 20 minutes. It's a miraculous feat. If anyone can do it, he can. And for you audience members, just a gentle reminder that if you have questions, to please fill out a note card. Kate, who's walking around, will be happy to collect them. Thank you so much, Kate, so that we're going to take questions at the end. Great.
Excuse me. So I've been tasked with discussing immigration remedies, what the options are out there for people who currently have DACA and who have TPS, whose status is expected to expire either on March 5th or as soon as your 2-year DACA status expires, or for the TPS registrants when their country status expires. There's about a dozen countries that have temporary protected status. They're all set to expire at sort of staggered intervals. And so one of the challenges for us as legal advocates is to reach as many of these people as possible, to screen them to see if there's something more permanent that they might be eligible for, and to transition them into those more permanent forms of immigration relief now, so that there is no gap in their coverage. So the ways that I'm going to cover very quickly in the next 15 minutes are family-based adjustment, which is the most common way that people get immigration status in this country, something called the 10-year cancellation of removal, Violence Against Women Act, U visas, T visas, a little bit about TPS, special immigrant juvenile status, and then asylum or refugee status. Okay, go. So for family-based immigration, it depends on a couple things. What my family relationship is, and there's only a couple that count. My parents, my spouse, my children, and my brothers and sisters. So those are the only ones that are recognized for petitioning purposes to get a green card. And if I have one of those family relationships, it also matters, are they a citizen or a green card holder? They have to be one or the other. But it also depends on how I came into the country. If I just crossed the border without inspection, even if I have a U.S. citizen spouse, I'm not going to be able to get my green card here. Even if I have a child who is born here and she's a citizen and she's 21, if I just cross the border, I cannot get my green card here. On the other hand, if I came in with a visa, typically a tourist visa, even though it was years ago and I stayed here, 20, 30 years without permission, but back home in my drawer, I still have that little piece of paper that showed that I was allowed in lawfully. Then, if I have certain family members, a citizen spouse or a child who was born here who's 21 or older, then I may be able to get my green card here, and all the time that I've been here without permission may get pardoned automatically. Now, even if I didn't come in lawfully in the beginning, so I just crossed the border from Canada or Mexico, or I landed on the Florida coast from Haiti or whatever it was, after getting DACA or after getting TPS, if I managed to travel, if I got government's permission to travel on what's called advanced parole, if I left and I came back in with permission, now I'm no longer someone who entered without inspection. And certain family members may be able to now file for me. And so some of the folks who have been here, let's say I came from El Salvador back in '95, and I traveled on advanced parole after getting TPS. I happen to be married to a citizen now. I may not realize that that trip that I took back in 2001 opened the door for me to get my green card based on this later marriage. And so finding those people and screening them for relief is critical. Now, if I did just come crossing the border, or if I have certain family relationships that don't waive my unlawful presence automatically, I'm not going to be able to get my green card here. I have to go to the U.S. consulate abroad in my home country and ask for my green card there. But typically, I'm going to trigger a 10-year bar. I'm not going to be able to come back in for 10 years. And it's one of the main reasons we have 11.5 million undocumented people in this country who may have a family member or an employer who wants to file for them, but they're not eligible to do it here. They have to go abroad. They'll be stuck for 10 years, and for most people, it doesn't make sense to do that. So there's a very limited waiver of that 10-year bar for some people, and it's called a provisional stateside waiver of unlawful presence. And you file for it with this Form 601A. And if I have certain family relations here, and if I can show that it would be an extreme hardship to them, then maybe I can ask for a pardon or a waiver of that 10-year bar, and I go abroad and I have my interview, and I know I can come back in, no problem. Now, it's only if I have a citizen or a green card holding spouse or parent, and for that person, it would be an extreme hardship. So it's not just that it would be financial hardship, so I happen to be the breadwinner in the family, and if I leave, it's going to be, they're not going to be able to pay their rent, and they're going to go into eviction, into the shelter system, and all the cascading sort of problems that happen. That's considered regular hardship for immigration purposes. But if my spouse has advanced cancer, or my child has a severe heart defect, and without me here taking care of them, it's going to be a hardship for them. And if they go back home with me to my home country and live with me there, it's going to be a hardship because maybe they're not going to get the level of care they need. So both hardship here without me and hardship back home with me. If I can prove all that, then I can get a waiver of this. So not that many people will fall into eligibility for this. And so it's a pretty small relief, small universe of folks who can qualify for this provisional waiver, but at least it exists. Now, there's a lot of rumors out there about this magical 10-year visa. And I get a lot of questions about, I've been here for 10 years and my daughter has asthma. I heard I can get my green card. Is that true? And the answer is maybe. There is something called cancellation of removal for non-permanent residents. And it's true that if I've been here for 10 years, and if I have certain family members for whom it would be, again, an extreme hardship, although this time it's not just an extreme hardship, but it's an exceptional and extremely unusual hardship, so like super-duper hardship, then maybe I can stay here and get my green card. And the family relationships are a U.S. citizen spouse or parent, like we just saw before, or child this time. So for my child, it would be an extreme hardship if I was not allowed to stay here, then maybe I can get my green card on this basis. Now, you cannot just apply for a cancellation of removal. You can't just send off an application and get it, even if it seems like you meet all the requirements. It's only a defense against deportation. So I have to be in removal proceedings in front of an immigration judge in order to be able to even ask for this. So it's a very risky thing to try to put into proceedings to get this. Now, what often happens is people will tell me, if you pay me $15,000 or $20,000, I can get you a work permit. And they're like, okay, that's amazing. I don't have that money, but my extended family will come up with the money and we'll pay this notario or this unscrupulous provider who's going to file something for me which I don't understand. And within a couple of months, I get a work permit, and I think everything is fine. And they've actually put into motion a chain of events that will hopefully lead to this. And what they've filed for me is political asylum, which I'll talk about in a moment. I probably don't qualify for political asylum, but while that's pending, I get a work permit, and I think everything is fine, but then suddenly I get a notice to appear in immigration court for removal proceedings. And I didn't understand that that's what I was signing. The attorney or notario didn't explain that to me. But the game plan was that once I'm in front of an immigration judge, we're going to swap out this frivolous or unmeritorious asylum application and substitute in its place a claim for cancellation of removal. But maybe the judge won't allow that, or maybe I don't actually have a qualifying family member, or maybe I can't prove extreme hardship to that person. So now I'm in removal proceedings. I didn't quite expect that I was going to be here. That notario has disappeared with my money, and now I'm facing removal. There's an estimate that about a third of the asylum filings currently pending in the New York immigration courts are this sort of unmeritorious asylum application, often from people who didn't even understand what they were signing. That being said, if I meet all the requirements, it is something that could lead to a green card, and it could cure the fact that I entered without inspection and give me permanent status. Now, for domestic violence survivors, there is a remedy under the Violence Against Women Act, VAWA. If I'm married to a citizen or a green card holder who's abusive, excuse me, or I'm a child of an abusive citizen or green card holder, or the parent of an abusive citizen or green card holder, this is elder abuse, and I can show that I suffered severe mental or physical abuse, then maybe I can get my green card on that basis. And this would be a way to go directly to green card, and the fact that I entered that permission gets pardoned automatically. But you have to suffer extreme abuse. So typically you would prove that by showing police domestic incident reports or orders of protection from family courts or criminal courts, maybe hospital records if it got to the point of emergency room visits. Sometimes just affidavits from friends and family talking about the abuse that happened and what they witnessed. U visas are another remedy for people who've been a victim of violent crimes. It could again be domestic violence, or it could be sexual assault, felonious assault. Some of my felonious assault clients are cab drivers or delivery people who were shot or stabbed in the course of their work. So to qualify for a U visa, which is a non-immigrant visa, it doesn't lead directly to a green card, but it's a way to stay here for a while. You have to have suffered physical or mental abuse, have been a victim of one of the listed very violent crimes typically, and you have to be helpful to law enforcement. The U visa was set up as essentially a quid pro quo to have undocumented crime victims come forward and be helpful to law enforcement. There was a recognition by Congress that in immigrant communities, people might be afraid to call the police because they're afraid that they themselves might get arrested and be put into removal proceedings. And so the enticement is come forward, report these crimes, and hopefully, there's no guarantee, but hopefully, law enforcement will certify you for this non-immigrant visa. And if you get that certification, with that we go to immigration to ask for this non-immigrant visa, which is good for 4 years. And during those 4 years, I can ask for my work permit and get a social and all that, stay here without fear of deportation. And after 3 of those years, I can ask for my green card. Now, there's tremendous family reunification with the U visa. If I'm the crime victim, if I'm an adult, I can ask for a derivative U visa for my spouse and my children. If I'm under 21, I can ask for one for my spouse and my children and my parents and my brothers and sisters who are under 18. And the family members can be here or abroad in the home country. And one of the great things about the U visa is you can ask for a waiver of almost any of the things that normally would bar you from getting immigration status. Criminal grounds that you normally can't waive, like under the Violence Against Women Act, if I have serious drug offenses, things like that, that would bar me from seeking a green card under VAWA, I can ask for a waiver under the U visa. It's not guaranteed, but it's possible. So it's one of the most flexible remedies that we have in the immigration in statute. Now, that being said, there's more people applying every year than there are U visas available. Right now, if I apply, the backlog is so long, I'm not going to be granted my U visa for almost 18 years. But probably after about 3 years, I'll get deferred action status, something similar to what we saw with DACA. And with that, I get a work permit and the right to stay here without fear of deportation, and hopefully that will continue as the years go by until my actual U visa is issued to me. The T visa is a similar non-immigrant visa for 4 years, but this is for people who've been here on account of trafficking. It could be forced sex work, or it could be non-sexual labor, either working in restaurants. Right now we're seeing a lot of diplomats, household help being abused. I have to show that I suffered a severe form of trafficking where there was some sort of fraud, force, or coercion involved, often involving the control of my documents. They keep my passport and my birth certificate, so it makes it harder for me to leave that situation. It could be because when they were bringing me into this country, they said, we'll safeguard your documents, and the road to the U.S. is perilous, and we will protect your documents and protect you. And I say, okay, great. So when I get here, they'll say, well, we're here, but I just changed the terms of our agreement. You owe me another $30,000, and until you pay that off, I'm not releasing you, and you have to work on my farm in the Central Valley of California or whatever it is. But if I can prove that that happened, I can get a trafficking visa. Now, I have to cooperate with law enforcement, which we saw with the U visa as well, but it's a little different. I don't have to get certification from law enforcement. I just have to report it, and often we'll just report to the Department of Justice. They have a civil rights office in DC, and that satisfies the requirement. If I can get actual certification, that's great. It makes it easier for me, but it's not necessary. And there's an exception for young people who are under 18 when they were trafficked. You don't have to report. Even if you're now an adult, but the trafficking happened before you turned 18, you're exempt from the reporting requirement, which can make it easier. And you don't have to cooperate with law enforcement if you can show that it would be a physical or psychological trauma for you to report. You also have to show it would be an extreme hardship for you if you were removed. Very different than the U visa, where you have to show that you suffered some serious harm as a result of the crime. Here you have to show that if you get sent back to your home country, that would be an extreme hardship. Now, the T visa is not oversubscribed. The U visa, there's 10,000 available each year, and there's almost 180,000 in the pipeline. The T visa, there's 5,000 available statutorily per year, and we've never come close to hitting the cap. And it's sort of unusual because I can probably go to the massage parlors in Flushing and get my 5,000 T visa clients in a day. But the fear, I think, with a lot of trafficking survivors is that you do have to report, even if you don't have to get actual certification, because the federal government wants to break up trafficking rings. And it could be that it's not safe for me to do that. So if I came from a small village in Guatemala and my family got the money together and paid the traffickers to bring me here, and now I'm prosecuting this trafficker, probably his or her associates back home are there and they can take it out on my family members, and so it may not be safe for me to do that. But for whatever the reasons are, the T visa is an underutilized remedy. But similar to the U, it's good for 4 years, the same sort of family reunification, and you can, what has been, okay, I've been given a note, but I'm going to keep going. And you can, with the T visa, after 3 years, just like with the U, you can apply for your green card. Now, one difference is if you can get law enforcement to certify that you were helpful with a trafficking claim and and that the investigation or prosecution is over, you can move directly to green card. You don't have to spend your whole 3 years in T visa status. You can go straight to green card. The question was, what is legal aid doing about DACA and TPS? What actually not just legal aid, but a lot of the nonprofits have been doing is, for years we've been doing large-scale TPS. I'm not sure why. I'm going to get to this later. I'm going to ignore the question for now. For TPS, so Alina described what temporary protected status is. The various countries are up for renewal. There are rumors out there that they might be extended for either 6 months or for 12 months. We saw this happen with Haiti, where they were given just a 6-month extension with an indication that use the 6 months to gather your, to renew your passport and prepare for deportation. Sudan was given 12 months with the same sort of notice. South Sudan actually got the full 18 months without a warning about deportation, but I think there's only less than 50 people in the country who have that, and so it wasn't like a huge thing. One thing about TPS is if you came in without permission, you just crossed the border without inspection, then normally you're not going to be able to get your green card here through certain family members or otherwise, unless you've traveled on advance parole and come back in with permission. There are 2 circuits that have said that the grant of TPS by itself is an admission that opens the door to getting your green card through, for instance, certain family members. But it's only the 6th Circuit in the Flores decision and the 9th Circuit in the, I forget, I think the Rodriguez decision. Starts with an R. Ramirez, sorry. So Ramirez in the 9th Circuit and Flores in the 6th Circuit say that the mere grant of TPS is an admission that's sufficient for an adjustment under Section 245A. The 2nd Circuit hasn't ruled on this yet. There was in this area, not quite in the 2nd Circuit, in the 3rd Circuit, there was a federal court judge in Pennsylvania who found the same thing, but it didn't go up to the circuit, and I believe there was a district court judge in Virginia as well. But nothing here, and so we're looking for sort of the model plaintiff to make ideally the same sort of good law here, because that would open up the door to a lot of TPS registrants who didn't have the opportunity to travel on advance parole, but who may have had a child who was born here and as the years have gone by has turned 21 and is a citizen, of course, through birth, or is married to a U.S. citizen and might be able to adjust on that basis. So for young people, there's something called Special Immigrant Juvenile Status, or SIJ, which is for kids who are under 21 who've been abused, neglected, or abandoned by one or both of their parents. And it's a way to get a green card directly, but you have to involve the state courts in some way. So it could be that you're in guardianship, foster care, or adoption. And you have to get what's called a special findings order from that state court judge, saying that it's not in the child's best interest to be returned to their home country and that they were, in fact, abused, neglected, or abandoned. They have to be unmarried, and certain crimes may make them ineligible. But if they meet all the requirements, it's a way to directly get a green card. You can, however, never petition for either of your parents, not even the one who is not abusive to you. For refugee and asylum status, this is for people who have a credible fear of being persecuted or tortured in their home country on the basis of one of 5 things: their race, religion, their national origin, membership in a particular social group, or their political opinion. This comes out of the definition of refugees in the UN Convention on Refugees that we signed on to, and it's the same thing for asylum. Refugees are folks outside the country seeking safe haven here. Asylees are already in the US seeking safe haven. That's the main difference. Refugees must apply for their green card after 1 year, and asylees may apply, and they should. Another big difference is refugees can only come from a country that was named as a refugee-giving country. For instance, Syria has been named as a country that can give us refugees. The conditions on the ground in Jordan across the border might be just as dire in certain parts, but Jordan is not a refugee-giving country. It's a very political determination. For asylum, on the other hand, no matter which country you're from, you can ask for asylum as long as it's a credible fear, right? As long as you can show through country conditions reports or what have you that you're at risk. If you're sent back home, then you can seek asylum. But you must do so within 1 year of arriving for asylum. And after 1 year in either status, you can ask for your green card. So in terms of what people are doing, I'm just going to answer your question very quickly. We've been registering people for TPS, and all the nonprofits around the city have been doing so since TPS was first created. There was a huge lift with Haitian TPS a couple years ago and with the Nepali TPS recently. For DACA, we've all been doing those registrations. Now that they're all running out, we're trying to reach as many as possible to see again if we can screen them for any of these forms of relief. Okay, that's all I have. Thank you.
Thank you so much. I hope you all learned all of immigration law in 20 minutes. That was amazing. Thank you. And now we're going to have Sienna Fontaine from Make the Road New York talk to us about access to public benefits and health care.
See if I can figure this out. Yeah. There we go.
Do F5.
Oop. 5. Oh, sweet. Hi, everybody. My PowerPoint is not as colorful as my co-presenters, but hopefully this will keep us grounded and organized as we move through some basic information. Just you see in my bio, but prior to coming to Make the Road 2 years ago, most of my work was in the public benefits world, and so that's where my joy really remains. So I'm excited to talk a little bit about benefits and how it applies to TPS and DACA folks. Let's see. Yes. Oh. Okay. So, but just to get started, I want to touch briefly upon eligibility for immigrants in general. As I think probably folks in the room have a varying degree of knowledge about government benefits. I'm not quite sure who's in the room. So we'll do a little bit of kind of base discussion. I want to discuss what's been available in New York State for DACA and TPS recipients. And then I want to discuss a teeny bit about what's at stake for those folks once any protections are potentially removed for them. I'll be focusing on a few key benefits that most of us, I think about when we're talking about government benefits broadly. So that's cash assistance, also known as welfare, Supplemental Nutrition Assistance Program, or SNAP. Most people know it as food stamps, and Medicaid and health insurance, and then we'll touch a little bit upon education benefits. So immigration eligibility generally. In order to receive federal benefits, an individual must be called a qualified immigrant, or in more technical and more offensive terms, a qualified alien. So who is a qualified immigrant? So you can see here this very long list of groups of immigrants that Hassan told us all about. But you know, the key groups that I think most of us are probably working with are legal permanent residents, asylees, refugees, victims of trafficking, and victims of violence. If you are not in one of these categories, then you most likely are not eligible for any federal benefits, but you might be eligible for city and state benefits. I'll get to that in a quick second. And to be eligible for city and state benefits, you likely are considered what's called PRUCAL, and that's permanently residing under the color of law. This is not like an immigration designation by USCIS. This is a category that's given to folks essentially just for eligibility of benefits. So it's not a federal immigration category. It's a category that we use to determine eligibility for benefits. And then if you're not a qualified immigrant, if you're not eligible for benefits under PRU-Call, you're likely undocumented and thus not eligible for any benefits at all. In New York, you are likely eligible for emergency medical assistance, but that pretty much is about it. I do want to note that if you're an undocumented parent, you can apply for federal benefits for your citizen or other eligible status children. And when you're making that application, you shouldn't be required to disclose your own immigration status during that application. So I just wanted to note that. But the parent would be required to provide any income information or other kinds of information that would help the agency determine what that child would be eligible for. I also want to just direct you to a really great resource that the Empire Justice Center has put together. I think benefits advocates have been using it for a really long time. I mean, you can find it on their website. It's essentially just an immigrant eligibility chart, which really details every benefit available and which categories of immigrants are eligible for what. So it's a really great resource if you're trying to figure out for clients that you might be seeing. Say it again. So the Empire Justice Center, their website, it should be pretty easy to find right on their website. A very handy chart. For public assistance purposes in New York State, there are essentially two pots of money that individuals can access. Let me skip. I feel like my slides are a little out of order. There is family assistance, which is funded by a federal block grant called Temporary Assistance to Needy Families. And there's the state program, which is called Safety Net Assistance, and that's a state-funded program. So here you can see the key differences in the program. So in order to be eligible for family assistance, you have to be a specially qualified immigrant, that list that we were just looking at. The household has to include a minor child or a pregnant woman, and the benefits are limited to 5 years or 60 months. Okay, and so that is which is a key distinction as we jump to safety net assistance, which is state-funded. It can include households without children, so singles are eligible for this for benefits under safety net assistance. Also, folks who time out, you're getting federal benefits, and you reach your 5 years, you then become eligible for safety net assistance. And other folks who don't qualify for family assistance, the federal dollars, because of their immigration status, potentially are eligible for benefits under safety net assistance, and that's cash assistance. One great thing about New York State is that we've declared in our state constitution that we have an obligation to care, provide for the needy. And so what this has translated to is essentially an ability to kind of pick up the slack where the federal government has failed in terms of welfare access to immigrants. So if you are unlucky to not live in New York State and you live in other states that don't have such generous policies, you might find yourself not eligible for any benefits because you don't qualify based on your immigration status, or you might be even if you do qualify based on your immigration status, you might time out after those 5 years, and then there's not any other benefit, safety net for you to pick up after those 5 years are up. So unfortunately, we haven't really picked up the slack in terms of SNAP. In order to receive food stamps, an individual must be a qualified immigrant, generally, but there are some exceptions to folks. Sorry, let me back up. To receive food stamps, you have to at least be a qualified immigrant, and for most people, they have to be in that status for 5 years. But there are some exceptions to that rule, and here are the different ways that people can qualify for food stamps. So like I said, you have to have been in the US for at least 5 years in that status as a qualified immigrant, or have 40 qualifying quarters of work, or you're receiving disability benefits, or you're a qualified immigrant and under 18 years of age, or you have military service that might qualify you. So this is kind of our broad understanding of qualified immigrant status. I mentioned PRUCAL, just to remind you that folks who are found to qualify for PRUCAL are only eligible for state and city benefits, no federal benefits. And again, if you're undocumented, not eligible for state and city benefits, emergency medical only, okay? So we covered, what TPS is, so I'm not gonna rehash it here. TPS and government benefits. So we've talked about, who qualifies for TPS. What government benefits are these individuals not entitled to receive, okay? So, there's a lot of myth, and, I'm always, shocked when I'm listening to kind of political commentary about the impact of immigrants on, the welfare system, or, they come to the country and they're receiving all these benefits. In reality, most immigrants aren't eligible for a lot of benefits. And so case in point here, folks who have TPS are not eligible for any of these federal benefits, okay? So that includes SNAP, right, food stamps, any cash assistance or welfare, under the Family Assistance federally funded program, Home Energy Assistance Program, which is a federally funded benefit to help you pay for your utilities, your Con Ed, your electricity. Supplemental Security Income, SSI, which is a welfare program for people who are disabled, and that is federal dollars. And then most housing assistance, right? So that includes public housing and Section 8 vouchers, which are all administered by HUD. So folks are not eligible for any of those federal benefits with TPS. What benefits are folks eligible for? So folks who have TPS are considered PRUCAL for the receipt of these benefits, okay? They're permanently residing here. The government knows that they're here and is not trying to actively deport them, okay? So eligible for medical assistance, such as Medicaid and Child Health Plus, which is another state-funded program. Under the Affordable Care Act, actually, people with TPS are able to purchase health insurance under the state marketplace. Okay, there's federal marketplace and state marketplace, and folks with TPS are able to purchase health insurance in the marketplace. Cash assistance provided through safety net assistance, but this only became effective in 2016 after the Empire Justice Center filed suit. Prior to that, folks with TPS were only PRUCAL for medical benefits and were not eligible for cash assistance benefits. But the Empire Justice Center sued on behalf of TPS individuals, and the Supreme Court, I guess in Erie County, found that the state agency, OTDA, the Office of Temporary Disability Assistance, their refusal to provide safety net to immigrants in TPS status violated the state constitution and the U.S. Constitution, okay? So folks with TPS are now eligible for cash assistance. WIC, which is a nutrition assistance program. Folks with TPS are eligible for WIC assistance. And as well, Social Security disability income. So as we talked about, folks who have TPS are working. They have work authorization, so they're paying into our Social Security system and are eligible to access disability benefits based on the earnings that they've made through their contributions that way. I'm going to skip this because we already covered it. Just a quick background on who the Dreamers are, and DACA. We went over what DACA is, but I did want to just remind you, like, who are our DACA folks, right? They are young people who have a certain level of education, because you can't receive DACA without having a high school diploma or a GED, and who have no criminal background, right? So we've got a very particular, group of folks who are DACA recipients. You've heard about some of our plaintiffs in our lawsuit, folks who are, who are very accomplished and who are really working to kind of, establish themselves here. So it's always interesting when we think about, kind of government benefits and who do we find to be deserving of those benefits. Something I want to talk about in a little bit. We talked about what DACA folks are eligible for, this temporary relief from deportation, work authorization, the ability to get a social security number, and a driver's license. Similar to TPS, DACA recipients are not eligible to receive any of those federal benefits that we pretty much went over, okay? Not eligible to receive food stamps, not eligible to receive a Section 8 voucher or have access to public housing. Not eligible to receive any, medical assistance that's provided by the federal government. As well, DACA, there was a special carve-out for DACA recipients to not be able to be eligible for purchasing insurance under the Affordable Care Act. And I think that it wasn't that way when it was first implemented, and then there was a later carve-out. So folks who receive DACA are not eligible to buy insurance on the market. And so there's a lot of benefits that our DACA recipients are not eligible to receive, as well as federal financial aid, which we'll talk about in a minute. Like TPS, folks who receive DACA are eligible to receive state-funded benefits, and that includes cash assistance through the Safety Net Assistance Program, as well as Medicaid, and they are considered PRUCAL for that. There was no fight like there was with TPS for DACA recipients to be considered PRUCAL for cash assistance. So just a quick note on education access. DACA students are not eligible for federal student aid. TPS students are not eligible for federal student aid. So that's a huge bar to the ability to afford college for most of those students. One thing that New York State has allowed is that folks who do have TPS eligibility or who have TPS status and DACA status are eligible to receive in-state tuition versus out-state tuition, as long as they can prove their lawful permanent resident. Their residence in New York State. But that's not the same for all states. I think there are about 15 states that allow for in-state tuition for folks who are DACA and have TPS. And so that obviously helps folks access because that means their tuition is lower, but it's still difficult to obtain kind of any financial assistance to afford even that in-state tuition. I think there are 5 states that allow those recipients to, and I don't have the list in front of me, but I think there's 5 states, not including New York, that allow folks to apply for state financial aid versus federal financial aid. And so each state is different, so it's important if you're counseling someone who doesn't live in New York to kind of find out what the rules are for their state. Students, and as most DACA folks may have a social security number if they've got their work authorization, they can complete a FAFSA. It might not be that helpful for them except to determine what their family contribution would be were they eligible, to figure out what their family contribution should be going forward. Okay, so those are kind of the key benefits I wanted to touch on today. A couple of things for us to think about. We're coming upon a potential moment when folks who are receiving TPS, folks who are receiving DACA are not going to have this protection anymore. And so we're going to have a huge number of people who don't have work authorization and are still going to be here. I think it's outrageous for us to think that people are going to pack up, and they shouldn't pack up their bags and head back to their home countries, many of which they haven't been to, as Alina talked about, for 20 years, more than 20 years, potentially, depending on the TPS. So now we're going to have folks whose work authorization has expired, and what are we going to do with those folks? We then eliminate their ability to access cash assistance or any kind of safety net. So it's going to create a huge issue for us as we see our neighbors, folks who potentially are homeowners or who are owning businesses not eligible to really sustain their families and sustain their lives, and not being eligible for any kind of benefit that otherwise would be a safety net for those folks. So what are we going to do? How are we going to think about providing for those folks? So it's really, I think, the states have had a lot of ability to maneuver where the federal government has failed, and the city as well. So I think we're going to have to really be, thinking creatively about how the state can respond. What are the legal ways that we can respond to create a safety net for folks who all of a sudden are going to find themselves without the ability to care for their families and care for themselves? Another thing I just wanted to quickly mention is the idea of public charge. Folks who receive, cash assistance, who are qualified immigrants, have run this risk of potentially being considered a public charge for the moment when they want to adjust their status. And so it's been an issue. It's always been an issue. But it's been a little bit more of an issue since February when Trump leaked a potential executive order that was looking to expand the kinds of benefits that would put someone at risk for being considered a public charge. So so right now I said it was cash assistance, or if you are in a long-term institution that's being paid for essentially by Medicaid, those are things that could put you at risk for a public charge finding later when you're trying to adjust your status and the government asks you, have you ever had to rely on the government for your subsistence? And that could be a potential bar against your being able to adjust or potentially put you at risk for deportation. Those are very specific benefits. Widening that circle could be really detrimental to folks who maybe after a long period of time needed food stamps for a particular moment or needed some other benefit that wasn't part of that calculation up until now. And the administration is now thinking about how to expand so that more people are getting pulled in to potentially being considered public charge and then at risk for deportation. And so these are things that we're thinking about. And Make the Road has been working and thinking with legal aid about a potential response and lawsuit should that leaked executive order actually be a real executive order that comes down. So these are things that we're thinking about as we're wanting to grant access to benefits for categories of immigrants. Is it going to put them at risk for a public charge determination later if somehow folks with DACA are finally able to get a path towards residency and citizenship? Is the ability for them to receive public assistance now going to put them at risk for a public charge determination later? So these are just all things that we need to be thinking about that are part of that calculation as we're trying to figure out what's the best way to support folks going forward. So that's all I have. Looking forward to questions.
Thank you so much, Sienna, for educating us about access to public benefits and also for your insightful commentary onto public charge. So now it's time for questions. Hooray, the long-anticipated question time. So to begin, we had a bunch of questions concerning what can those of us who are not immigration lawyers or not lawyers do to help. And some of these questions were directed specifically at Amy and Alina, and others were at everybody. So panelists, I turn it over to you. What can non-lawyers and non-immigration lawyers do to help our friends with DACA and TPS?
Great question. Really important to be thinking about that. I think it's really important that we all continue to speak up about our outrage around the potential end to the TPS program as well as the DACA rescission in whatever way works for you personally. At Make the Road, we do have a new network of allies called Aliatics, where we have monthly meetings to engage people who want to be active in the Trump response, whether that means helping make posters, researching potential, issues we can work on, turning out people to protests, speaking at events. There are a lot of different ways you can get involved, so I would encourage you to join that network. Specifically around DACA, I'm sure you all know that this fight is very live in Congress right now. If anyone happens to live in Donovan or Kings districts in New York, they're incredibly essential Congress members for the vote on the DREAM Act. Call your Congress member, ask them to support a clean DREAM Act without increased immigration enforcement and a border wall included in that legislation. There's also a bill that I believe was introduced maybe even today. It's a TPS fix bill, and I can't remember the name off the top of my head. Does anyone? So there's definitely, individual advocacy that can be done around, legislation in Congress. And I will pass it to my fellow panelists for other ideas.
Yeah, I think I would just add to that. Well, I mean, one of the touchstones is to really support organizations that are doing organizing work with people who are directly affected. So Make the Road, the New York State Youth Leadership Council. There's a number of organizations of people who are fundraising. So I mean, that obviously is a big need, because they fundraise not only to support organizing education protests, but also things like scholarship funds for students who may lose their work authorization or who were never eligible to begin with. So I think that's a huge thing that people can do, is to support those organizations and to donate. And the only thing in addition to the federal legislation is to really push our state to do everything that it can. It's unconscionable that we don't have driver's licenses for undocumented people, that it even matters that you have to have work authorization. That is a huge risk factor, because it becomes a pipeline to deportation for people who then get arrested for driving without a license and suddenly find themselves in the system. If you think particularly outside of New York City, Long Island, upstate New York, you have to drive to survive in this state. So why does New York State not have driver's licenses for everyone? Why are they putting people who have DACA and TPS in this precarious position? There's no need for it, so we can step up as a state in that respect. Similarly, in terms of what Sienna was talking about, in terms of providing state scholarships, really being much more robust in what we offer to people, and to stop using things like work authorization, which we have learned now is completely precarious, or immigration status at all, as a marker for what kinds of rights and benefits you have in this state. We have control over that, so we can be pushing internally in our blue state for those kinds of policies and really making a mark that way. And I know many of the organizations here are involved in those efforts and trying to build a base of support for that, which I think is incredibly important, because I don't know that we can really rely on Congress, even though we have to put the pressure on them to fight for this legislation to save the DREAM Act, to save DACA, have a DREAM Act, and save TPS. To do that and to fix the problems that are in the system, we have to keep our eyes on the federal prize. But I mean, in New York State, there's a lot we can do. And also, there are some very innovative programs in New York City as a result of advocacy here, in terms of funding for public defenders, for detained New Yorkers, a lot of our detainer policies that exist here that don't exist in other parts of the state. So in particular, if you have ties to other parts of the state and are trying to push that progressive legislation, there is a blueprint for that can happen on a very local, kind of county-by-county level.
So I'll just add a little bit to that. So I agree with the driver's licenses. I think the 2005 the Federal Real ID Act ties states' hands to some extent, but whatever we can do within those limitations, we should. In terms of the demonstrations, DACA came out of demonstrations, and certainly after the inauguration this year, there's been a lot of street demonstrations. One thing that we can do if you don't feel like being a direct demonstrator is join the National Lawyers Guild and be the green hat folks who go out and make sure that the police are acting appropriately, or if they're not, that you're documenting what they're doing inappropriately, so that a record is made, and that can be super helpful to support the demonstrators.
Great, thank you. And I think we have some more questions. So before I turn it over to you, I'm going to turn to Amy and Diane to ask a more litigation type question. And the participant has asked, what do you anticipate will happen once DACA and TPS expire? Will they be removed? Will there be an injunction in either case? So that was to Amy and Diane, but I open it to anyone.
So that's just to clarify the question. What would happen?
What do you anticipate will happen once DACA and TPS expire? Will they be removed or an injunction in either case?
Sorry, I just want the clarification is: will they be removed? Will DACA and TPS be removed? Individuals be removed?
Well, I guess
people
will
be removed. Okay,
yes.
so I understand. So the DOJ has repeatedly said publicly that they haven't made plans to prioritize removing individuals who are DACA recipients. But of course, we have to see what happens. But they have reiterated that in our court appearances. They have said that in other places, and so I hope that's true, that they're not going to prioritize their removal, but as we know, they no longer have protections from removal. So once, and I'm talking about DACA because I'm not as familiar with TPS. So once DACA is terminated, former DACA recipients are subject to removal. They can be removed. And so what we are seeking for this to be enjoined. That is what we would like. We would like for the government to be stopped from doing this. And that's the purpose of our case. So we hope that would happen, and we hope that if that did happen in the district court, that it would survive appeal. So we just have to wait and see.
So just want to add one thing. So if I have DACA or TPS and my status expires and the government wants to deport me, they can't just put me on a plane and deport me. I'm entitled to due process, and they have to serve me a notice to appear in court. And what could happen is, and that whole process can take months or years, the government could just do a mail merge and just send out hundreds of thousands of notices to appear to make it clear that your status has been terminated and that you don't have PRU-call and you don't get benefits and all that kind of stuff, and then slowly file those with the court and slowly go through the process of removal. It'd be a simple thing that they could do that would be incredibly damaging. But also, a lot of people have final orders of removal already. We saw that a lot of the El Salvadorians had sought asylum when were denied and had final orders and then got into TPS. A lot of the Haitians, too, who came in the 90s on the Florida coast, sought asylum or denied, have final orders. You can get asylum, you can get TPS or DACA over a removal order, but once you lose that status, the government can just reinstate that order and deport you without any further due process unless you can show you have a reasonable fear of torture or other terrible things. It's going to be incredibly a fraught time, particularly for people with prior orders now.
Thank you. So, Hassan, I'm going to keep it with you. Okay, so I guess two questions here. What should impacted or affected individuals, what would your advice be to them as an immigration lawyer? And what are some challenges that you're seeing at Legal Aid, perhaps some that might not have been mentioned among the people that are coming to you for help?
I think for impacted people, and by impacted I assume we're talking about DACA and TPS folks who are about to lose their status, meet with an immigration expert now, whether it's through Legal Aid or any of the agencies that are out there. This is a time when notarios and unscrupulous practitioners take advantage of fears and will charge thousands of dollars to file things that you're not actually eligible for. So meet with someone who can tell you if there is anything, and if not, it's helpful to know that too. It's helpful to know that there's no immigration relief available to you at this time, and don't file something that will end up causing your removal most likely. In terms of the challenges that are out there, there's a lot of things that have changed under immigration law under this administration right now with unaccompanied minor children in particular. That's like a whole evening discussion. They're at great risk of losing their special designation as unaccompanied minor children. The adults that they were released to, the sponsors, are going to be targeted for arrest and alien smuggling. I think those are two of the big things that we're particularly worried about right now.
Great, thank you. And back to when we were talking about DACA and we were talking about the idea of it ending, we've also heard media reports that the president could perhaps extend the DACA program if Congress fails to pass a legislative fix for DACA recipients and DACA eligible individuals. The participant asks, as you know, DHS gave certain DACA recipients who are eligible to request extensions only 30 days to do so without providing specific notification. How realistic are the prospects that DACA will be extended? And assuming it is, how do you see this as being implemented?
Well, sure. I think that any questions about what the president will do are extremely hard to answer. Obviously, you know, we have zero faith that this president has any desire to help immigrant communities. And in our case, we raised the arbitrary October 5th deadline numerous times, and it's a core part of our claims that, you know, the announcement on September 5th, which gave such a short timeline for so many individuals to get their renewal applications in, was arbitrary and capricious under the law and incredibly burdensome for organizations like ours to meet that demand and to get these renewal applications filed, not to mention the number of people affected by hurricanes across the country who may have had difficulty collecting documents that they needed to file their renewal, or, you know, the $465 fee required every 2 years to renew your DACA application, so, which is really hard for a lot of young people to come up with. So we consistently, you know, raised that. And the judge in our case consistently raised the, you know, heartless and burdensome deadline with the DOJ lawyers and pressed them to go back to their client and extend that deadline, which the government refused to do. So it seems unlikely that, you know, now that the deadline has come and gone, and we know that there are somewhere around 4,000 people who filed renewal applications that arrived after October 5th, and it looks like they will be rejected, as well as, you know, the thousands of other people who did not file renewals for unknown reasons at this point, that there will be a large number of people directly impacted by that deadline. So there exists the possibility that we could raise in our case with the court, you know, seek a preliminary injunction around the October 5th deadline on behalf of impacted individuals, but we haven't made that decision yet. But in terms of the government voluntarily extending the deadline, I would say that the chances are pretty slim.
Okay, moving on. A participant asks, have you heard of instances where DACA recipients that missed the renewal deadline received letters to appear at Varick Street? Varick Street, for those of you who don't know, is the detained immigration court. And if so, how would you advise such clients?
Yeah. So we haven't heard of DACA folks whose status has expired and were not able to renew. I haven't heard of them being put into removal proceedings. If they got a notice in the mail, by the way, it would not be for Varick Street, which is for the detained immigrant population. Theirs would be noticed for 26 Federal Plaza, the main federal building downtown. If I'm detained, my case will be venued at Varick Street, but I'll be in immigration detention, and that's where I'll get all my notices.
Okay, so you have not heard of such? No.
So far, no.
So far, no. Okay, another panelist asks, have immigration judges' deportation hearings become tougher, tougher is in quotes, under the Trump administration?
Go for it.
Yes. A lot of what happens in immigration court is discretionary, and the government attorneys, the ICE attorneys who oppose us and are seeking our clients' removal, in the past had exercised a lot of discretion in our clients' favor. And with the executive orders that President Trump signed on January 25th, he basically took away a lot of discretion. Before it was, if you had serious criminal convictions or if you had repeat immigration violations, you keep coming in after you're deported, you're going to be a high enforcement priority. But otherwise, they may exercise discretion to allow you to stay and not fight your deportation tooth and nail. Now we're finding that they're fighting us tooth and nail on everything.
Yeah, I'll add a couple of words on that because I completely agree. And we've also seen, beyond the lack of discretion, tactics that are making these cases incredibly hard to litigate and much more resource intensive. So one thing we've been seeing are old cases that were administratively closed, so kind of put in a file sitting there without any action being taken. We're seeing them reopened and recalendared, so we now have, old cases coming back as active cases on our docket. And then with applications filed with USCIS, we're seeing a lot more what are called requests for evidence, which is when the agency comes and says, well, I need you to submit X, Y, and Z before we can consider this application, and notices of intent to deny. And in both of these instances, there's a very short timeline to provide that information to the agency. And in like a special immigrant juvenile case, for example, that often requires going back into family court and actually relitigating the underlying family court case to get a new special findings order from the family court judge. And then just generally more complex litigation. So, since we're seeing more ICE enforcement actions, we have more clients who are detained, so we're doing more habeas work, more appeals, just everything is more contentious and much harder to fight.
Thank you, Amy. Diane?
Yeah, I'm just going to add, so I don't practice in immigration court, but one thing we're concerned about is the federal government changing its practice of allowing a stay on immigration proceedings if someone is eligible for DACA but hadn't applied. And so if they're in immigration court and they're eligible, the practice, as far as I've heard, used to be that they would stay the deportation proceedings in order for that person to apply for DACA. Since they were eligible, and they would likely get it. We're concerned about that no longer being the case and those people being subject to deportation as a result.
Thank you. Okay, and we have about 4 questions that ask sort of particulars in terms of immigration law on applying for asylum and TPS, and I know you all know these, so we'll sort of rapid fire this up. Can an application for asylum be converted to an application for TPS or vice versa? Yep. Hassan?
So no.
For 200? Okay.
So the two are very different statutory remedies. Your application for asylum and your application for TPS are filed on totally different forms, and your eligibility requirements are completely different. So if you do somehow meet the requirements for both, it's much more advantageous to apply for asylum because it's a more permanent remedy, and after a year you can apply for your green card.
Great, thank you.
To the extent the questioner was asking if somebody has TPS, should be considering whether or not they might be eligible for asylum in case their TPS is revoked. That is certainly something people should do, and it is quite possible for there to be overlap, that a person can be eligible for both even though they're very different kinds of applications. And so that's one of the things that I know Legal Aid and other groups are doing, is encouraging people to come forward to have those screenings.
Great, exactly. And on a more final note, it's hard in this climate to feel as advocates as though we're in a defensive posture, working on particular issues with particular groups. Is there a way that we could push for broader changes to both the immigration and social welfare regimes? And are there any big asks that we should be pushing for? Alina. Alina's smiling. Yes.
Yes. So I mean, I think this is an area of great debate right now because, so first, talking at the federal level, there is a lot of discussion about trade-offs, and ultimately the people who are directly affected by these issues have to be the ones making the decisions about what those trade-offs will be. So this, again, for example, is the idea, do we want to accept a DREAM Act-like piece of legislation that comes with border enforcement, the wall, interior enforcement. And that's why many of the people who've been organizing on the ground, like Make the Road and others, have really been pushing for a clean dream bill. And so for those of you who aren't familiar just with this term of clean dream bill, I definitely recommend that you go to these organizations' websites. There's a lot of explainers. UndocuBlock just put out a great video, I think today, explaining what a clean dream act means. But essentially, our asks generally, the direction that we're taking from people directly affected is that the asks do have to be clean, and that if we think that we can bargain away some aspect of our rights because of how bad things are, then we've already lost. I think there's a stat out there that 1 in 5, DACA recipients lives in a border state. So the idea that saying that you would be actually protecting them and their families by giving a dream bill that then has, a wall and, however many thousands of Border Patrol agents on the ground just doesn't reflect the reality. So I think we all have to be conscious of that, and we do have to ask for a very comprehensive solution. And then on the local level, I think we have to repeat those things, like, whether it comes, like Hassan mentioned, the Real ID Act restricts what states can do on driver's licenses. It doesn't restrict states from providing identification and from not criminalizing unlicensed driving if they have that kind of identification. So there's a lot of creative, positive things that states can do to protect immigrants that, frankly, are not being done for political reasons, and so we can push back on that level. Locally, we have to be wary of these politics. When the New York Immigrant Family Unity Project was first piloted, and this is the project that gives people defense attorneys if they're detained as New Yorkers in our detained immigration court at Varick Street. It was a incredible success, made huge differences in people's outcomes. City Council supported it, expanded it, and then when we asked for Mayor de Blasio to put that baseline that into the budget and to provide the funding necessary, he and the Mayor's Office for Immigrant Affairs took the position that people with certain serious, quote-unquote, serious convictions shouldn't be given lawyers. And, again, people fought back against that, and, the NYFA providers, including legal aid, really spoke out, and a compromise was reached and funding was magically found so that the program continues to be universal. But I absolutely, whoever asked that question, I think you're spot on that every solution we come up with has to be comprehensive, and that any time we scapegoat a segment of our population, for whatever the reasons are, we ultimately are losing. And that if you take, as lawyers, if you take the universal representation model as an example, it just demonstrates that if the idea that one would propose that you could take away lawyers for some people and somehow still get a fair legal system, even for the people who still get lawyers, shows that they aren't actually aware of what goes on in court and how laws are made based on the first person the judge sees and how they view the case, and suddenly that applies to everyone. So that's just one of many reasons why all of our solutions have to be creative and comprehensive, and that there's a lot that we can do locally to push for fair immigration policies and have that percolate up. And I think that's important for us to keep in mind.
Just like to piggyback on that just very briefly. I completely agree with that. And federally, ideally, what we should be pushing for is comprehensive immigration reform. We had the Senate pass Senate Bill 744 back in March of 2013, where there was a pathway to eventual permanent residence for most people. The DREAM Act was part of it. The Agricultural Jobs Bill was part of it. STEM Act was part of it. And it passed the Senate. It had enough votes to pass in the House, but John Boehner refused to let it come up for a vote. So the political climate is very different now, but ideally that's really what should happen to give a pathway to legalization for the 11.5 million undocumented people in the country.
Thank you. With that, I want to thank all of our panelists for being here tonight, to Amy, to Alina, to Sienna, to Hassan, and to Diane, and invite Yuri from the New York State Bar Association up. I know there was a special presentation that he wanted to make very briefly before we close it for the night. So come on up, Yuri, and thank you all.
Good evening. My name is Yuri Peresovsky. I'm the Immigration Pro Bono Fellow with the New York State Bar Association. Can I just go ahead and, thank you. And I'm here to talk about the project that I work on, and that's the Immigration Pro Bono portal. And by the way, thank you to the New York City Bar for allowing me to speak at this event. So this project has been created in partnership between the New York State Bar Association and the New York Bar Foundation. And the idea behind it is very simple. So on one hand, you have a lot of volunteer attorneys who are very motivated at this time to volunteer their time to help our immigrant communities. And on the other hand, you have a lot of legal services organizations who do a lot of great work trying to resolve these issues. So this portal allows organizations to post their listings describing their pro bono projects and detailing the needs for volunteer pro bono attorneys. And on the other hand, volunteer attorneys can register by filling out a short questionnaire about their skills and experience and receive, so this is what it looks like. Once they let us know about their skills and experience, they can receive customized referrals to volunteer opportunities based on their needs and abilities. Or they can browse the listings themselves, like on a website, and volunteer, thank you, to the opportunities that are of most interest to them. And the listings are basically here. The portal also hosts a variety of training materials and resources, which is available here. Resources, some basic library of things. And then we also have a calendar of training events. So since January, thousands of attorneys across the state have volunteered to assist immigrants after the federal government initiated heightened enforcement efforts, and the portal has been kind of inspired by this overwhelming response to try to help our communities and legal services organizations. We encourage the attorneys who are interested in volunteering their time to visit the portal. Again, the website address is nisbaprobono.org, and fill out their listings questionnaire. For attorneys, we encourage them to fill out the attorney questionnaire so that we can connect the two with tailored referrals.
Great.
Again, that's basically it. If you have any questions, you could reach me directly at probonoportal@nisba.org. You can call me directly at 518-487-5642. And just as a note, you don't have to be a member, or this is a free service. So I encourage you all to sign up and do the great work. Thank you.
Great. Thank you, Yuri. And thank you to our panelists, again, for sharing your time and your expertise with all of us and helping us to learn about these important issues. We're going to have to end as we are out of time. I know there's a couple case-specific questions that people asked, and I'm sure our panelists can hopefully hang out for a couple minutes afterwards to talk to you all. So thank you again, and thank you to the committees for co-hosting and organizing, and to Make the Road for being here. Have a good night, everybody.